We have MALOCH versus MALOCH, case 19-2490 next. Whenever you get all unpacked, you can head over to the podium at your pleasure.
May it please the court, my name is Rebecca Creed of Creed and Gowdy on behalf of Laura Davis, the former wife appellant. The former wife asked this court to reverse the trial court's order, which rejected the magistrate's report and recommendations and found that the former wife was not entitled to a $2,500 modified alimony amount, which was an increase recommended by the magistrate of $1,400, and which it's undisputed that the former husband has the ability to pay. The magistrate did not clearly err in her legal conclusions. She did not misconceive the effect of the facts and the evidence, and she applied the correct legal standard. The trial court itself...
What do you think the standard of review is for the trial court reviewing a magistrate's decision?
For the trial court reviewing a magistrate's decision, it is limited to, essentially like this court, it reviews only to determine whether competent substantial evidence supports the magistrate's findings. If there is competent substantial evidence to support the magistrate's findings, then it is really bound by those findings. And as to legal error, only if the magistrate has been found to have clearly erred is the trial court entitled to reject those legal conclusions, or if the magistrate somehow misconceived the legal effect of the evidence. And here, there's no indication that the magistrate committed either type of error. The record is replete with competent substantial evidence that supports the magistrate's specific findings on page 545 of the record that the former wife has demonstrated a substantial change in circumstances regarding her need for alimony since the entry of the last order. The magistrate did correctly use the standard that the trial court refers to in terms of measuring when the change of circumstances occurs, which was since the 2016 order.
Counsel, doesn't there have to be a determination as to whether we're talking about the imputation of income, of whether it was voluntary or involuntary, her underemployment?
No, respectfully, Your Honor, that's not what the former husband argued for. There was no question raised by the former husband at the evidentiary hearing as to whether her imputed income at $43,000 should be increased. There was no proof of the types of standards that you have to meet to adjust that imputation of income, and the magistrate makes specific detailed findings as to the former wife's testimony and ultimately concludes that there's just not enough to show that the imputation of income of earnings of $43,000 should be set aside or should somehow be changed. The trial court in its order makes a number of misstatements of fact, including that the magistrate and that the former wife didn't address this rental income issue. Specifically, the former wife in her affidavit does explain how she reaches the number that she uses for rental income, and the magistrate again makes specific findings on pages 544 and 545 of the record that the former wife reports it's about $460 per month in rental income, which appears to be the net income. The former wife has a total of imputed and rental income of approximately $4,000 per month. Notwithstanding that, there was evidence to show that the wife's monthly expenses, as found by the magistrate, exceeded that, even with the alimony of $1,100 a month, which was the 2016 rate, and that she had a need that was not met by the current rate of alimony. As the magistrate specifically finds, the former wife has borrowed money to meet her expenses and has now dissipated her assets to repay those loans. So once the magistrate finds that there is a substantial change in circumstances regarding the need for alimony, she then turns to how do you determine that amount of alimony. And she does consider the lifestyle enjoyed during the marriage, which again is the correct ruling under Florida law. This court in Mirsky, in fact, reversed an order on modification, but because it did not consider the standards and the criteria required under Section 61.08 in a modification proceeding. This court's ruling in Mirsky has been followed by many appellate courts in Florida, including the 4th DCA in the Dunoff case, in which that court said that all applicable Section 61.082 factors must be considered in modification proceedings under Section 61.14. The language of 61.08 itself finds or provides that in determining the amount of alimony or determining alimony, these are the factors that need to be considered, including the standard of living established during the marriage. And as the Dunoff case explained, while the standard of living is not, quote, a super factor in setting the amount of alimony, end quote, it does have a case-specific and limited purpose. And here that purpose was met because the standard of marriage, the standard of living during the marriage was significantly high. There's really no dispute. Even the former husband conceded that the parties had an upper middle class lifestyle. They traveled, they owned numerous cars, several homes, or had interest in timeshares for vacation homes, and raised 4 children. The parties had agreed that the wife would stay at home and be a stay-at-home mom to the 4 children. They were married for 28 years. So all of those circumstances here allow the magistrate to rely on the marital lifestyle in finding that the current rate of alimony was at $1,100 from 2016 was not enough to satisfy or to meet the wife's needs and expenses. As the 4th TCA explains in the Dunoff case, the purpose of using this marital standard is to avoid having alimony set at bare subsistence levels. And here, where the former husband exposed this wife during the marriage to a standard well beyond the basic necessaries of life, he should be required to do better than mere subsistence with alimony. Here, there's evidence that the former wife was dissipating her assets, including an asset that the trial court specifically found in 2016 that she had, which was the $76,000 or $78,000 annuity. That those circumstances, her circumstances had changed such that she had to borrow money to meet her expenses, and she's now dissipated her assets to repay those loans. The magistrate did not consider necessarily the amounts that were used by the former wife in estimating the household repairs from the hurricane and to estimate her costs for obtaining health and dental insurance. But again, there's nothing to refute that she did incur those expenses, even if the magistrate didn't necessarily credit her amount. The former wife testified that she no longer has health insurance and dental insurance, that she can't afford to see the doctor for medical conditions that she has, that she can't afford even to see an optometrist to get eyeglasses. When she rents out her home, which she attempts to do to generate income, she testified that she either goes and stays with friends or she lives in a property, a small shed warehouse at the back of her property. And this is more than enough to show that to not allow this former wife, to receive alimony of $2,500 a month when the former husband is earning in excess of $16,000 a month, that reduces her basically to a bare subsistence standard of living.
Counsel, did the magistrate make a finding specifically as to the voluntary nature of the dissipation of the annuity?
I think the magistrate made a finding as to the involuntary that would at least suggest an involuntary dissipation of the annuity, because she states that the former wife has borrowed money to meet her expenses and has now dissipated her assets to repay those loans. The magistrate also states, explains that the former wife testified she liquidated the annuity in July 2016, which was after the April 2016 order, and used the funds to pay credit cards and loans, and also that the former wife testified that she used the annuity to pay credit cards to repay loans to her family, which she had obligated herself to repay, and also that she used that amount to pay the mortgage.
But the trial court seemed to really take issue with that, because the trial court's point was, well, that's not necessarily involuntary. That might be voluntary. If you choose not to work, but you have bills, you're paying them some other way, and she's using the annuity to do that. So did the magistrate specifically make a finding as to that, or did the trial court just assume a finding?
Again, I believe the magistrate's findings are enough to conclude that there was an involuntary dissipation, because even with her imputed income, her rental income, and her alimony income, she didn't have enough to meet her expenses. And so this is not a circumstance where the former wife is arguing, well, I'm just entitled to work 2 days a week, and I don't need to work anymore. Her income, first of all, was still imputed at $43,000 by the magistrate. There was no showing that should have been increased. And her change of circumstances did establish a need for alimony that required her to borrow money to meet her expenses and had to dissipate those assets. In terms...
Is the inference enough, or does there need to be a specific finding?
Given the language of
involuntary dissipation.
Well, given the language of the magistrate's order, I believe it is enough as it's written. I don't believe that there needs to be a specific requirement or finding that she involuntarily dissipated the assets when it is clear from a reading of the magistrate's ruling and the magistrate's findings of fact that the former wife was essentially forced to use that asset to repay loans, again, that she had obligated herself to pay, that she used that to pay her mortgage, and that the total of her income was not enough to satisfy her expenses, even at the reduced level that the magistrate found she was entitled or had shown.
Let me ask you this. How far back can the trial court, the magistrate, and how far back can we look? Can we look back to the party stipulation when the husband was employed with a good job and he agreed to pay $5,500 a month, I think it was?
Yes.
Then when he loses his job, that's obviously a substantial change. The alimony comes down. Now he's reemployed, not at the same rate, but pretty close. Are we allowed to look back that far, or can we only look back to the more recent changes?
In terms of determining the substantial change in circumstances, the case law is that you should look to the 2016 order and see whether there has been a change since then. But in terms of evaluating the entire set of circumstances, I do believe it's appropriate to look to these other factors, such as the length of the marriage, what the parties had agreed essentially would be the role of each spouse in the marriage, and the fact that at the time that the husband was earning significantly or substantially the same amount of money that he now is in 2009, he did agree to pay $5,500 a month in alimony. And as the magistrate found, the former husband previously agreed to pay alimony over double what is currently recommended while earning substantially the same amount as his present salary. Therefore, he has the present ability to pay alimony of $2,500 per month. Even though there have been changes in the former husband's employment, those reflect, as found by the magistrate, that he still consistently has earned over $200,000, notwithstanding that he may have had periods of unemployment. The former husband himself testified that he's had a series of jobs and that some of that employment, some of those, a couple, were only ever anticipated to be temporary positions. And so it is established that he does have the income at present to pay to pay $2,500 a month, which again is $3,000 less than what he had consented to in 2009. The finding of the trial court as to the effect of res judicata would essentially preclude any modification of alimony, because every time a modification was sought, the opposing spouse could point to whatever had been established by the final judgment of dissolution, and that is not what the law is in Florida. Instead, again, as we argued in the Dunoff case, following Mirsky, the court is entitled to look to all applicable Section 61.08 factors, and this is also established by the very language of Chapter 61 itself, which allows for modifications based on changed circumstances. Again, the former husband has the ability to pay. He's never contested that he has the ability to pay this $2,500 a month. He's still earning more than $200,000. It was a 28-year marriage, and the parties had agreed that the former wife would stay home and raise the children. And again, this former wife should not be left in dire circumstances, especially given the fact that, as the magistrate found, she did show a substantial change in circumstances, and that allowing for tax implications and upon consideration of the evidence presented, her current need for alimony is $2,500 per month. So we ask this court to reverse the trial court's order that sets aside the magistrate's report and recommendations, and to remand with instructions that the trial court follow and adopt the magistrate's very well-reasoned and well-supported report and recommendations. Thank you.
Thank you.